All rise. Honorable Justices of the Supreme Court. Hear you. Court from recess.
Please be seated. Morning, welcome to council. I'll ask Mr. Doug Sheehan, the clerk of the Kansas Appellate Court, to please call the 10:30 docket.
Thank you, Honor.
The 10:30 a.m. docket for Wednesday, December 13th, 2023 consists of one case, appeal number 125717, State of Kansas versus Christopher L. Klesath, Shawnee County, briefs both sides.
Good morning. May it please the court, Ryan Enninger, Assistant Appellate Defender, appearing on behalf of the appellant, Christopher Klesath. President, ready for argument.
May it please the court, Assistant District Attorney Carolyn Smith on behalf of the state of Kansas, present and ready for argument.
Your Honor, that concludes our docket for today.
Thank you. Council, please come forward and.
May it please the court, Ryan Enninger, appearing on behalf of Christopher Klesath. With the court's permission, I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you, Your Honor. We're here today after a Shawnee County jury convicted my client, Christopher Klesath, of felony murder with the predicate felony of aggravated robbery, along with second-degree murder. And Mr. Klesath also, after trial, entered a plea to a single count of criminal possession of a firearm. That second-degree murder merged with the felony murder at sentencing, and the district court imposed a 620-month sentence. I'd like to focus this morning on the second issue raised in our appellate brief. Unless the court had wanted to direct me otherwise, I'd like to
Let me do that, counsel, because do you agree with the state's brief that says if there's sufficient evidence on the ag robbery that supports felony murder, that we don't have to address the other ways?
No, I don't.
Why not?
So if there's
Doesn't everything, other issues all fit in the fiction that was merged or at least sentenced
right, it was
with the felony murder? And so if the felony murder is good,
my understanding
why
would
is
be
there
that,
any other issue?
well, that if there's a merger, then if the conviction for felony murder would be reversed, then it would seem that that merged count wouldn't then just stand.
Well, yeah, but that means we need to decide first whether there's sufficient evidence to support the felony
Okay, yes,
murder.
okay, I see what you're saying. Right.
Because then we don't have to do the
Without
rest
that,
of
without the predicate felony, if
Right.
there isn't, then that's why I raised the issue. So no, I do understand what you're saying. So
And do you
I mean,
agree with it? I mean, that's the point the state makes in their brief.
right, that is, I think that is correct. And that's, why that issue is there is that.
Then why don't we
there's-
focus on that first, at least, just
That's fine.
what
I
your
don't,
issues. I just think the sequencing of the issues is kind
sure,
of
I understand that.
important for efficiency.
So yes, the first issue regarding the sufficiency of the evidence for aggravated robbery. Basically what I've argued in that brief is that under those circumstances, there was really due to the fact that our video has no audio, the only actual indication of what was really going on there came from the testimony of eyewitnesses that were very equivocal at trial. There was some element, and what I've argued is that there's really no evidence that I guess the evidence was from these three eyewitnesses, Mr. Young, Mr. Locke, and I think it was Mr. Keeling. They both went back and forth numerous times as to what they heard, what they saw, Whether, I think one of the witnesses initially wanted to say that he wasn't even present. Under those circumstances, I've argued that I don't see how any reasonable juror would have found any of their testimony credible. And then so you have to look then at what Mr. Klesath testified as well to, and that was basically on these 3 prior incidences that we've had that were documented throughout the trial, and there's testimony to support that. Mr. Klesath said, look, we had this initial situation where the victim, Mr. Fields, shot me along with my girlfriend. After that, he told me maybe we should talk about this, maybe we can work things out. I went to his house. He threatened me again and said, yeah, I accidentally shot you last time. This time could be on purpose. And then we had a subsequent encounter where my client was walking down the street, encountered Mr. Fields. Mr. Fields said, you know, one of these times I'll catch you slipping. And then we get to the actual incident at Charlie's liquor store where, my client's coming up, Mr. Fields says something to him along the lines of, I'm going to shoot you. And I think if you watch the video, State's Exhibit 1, I think is what it was, you can see that Mr. Klesath, my client, is walking past Mr. Fields. Mr. Fields' his head turns to my client, and as he's moving his hand this way, he definitely says something to him at that point.
Let me just interrupt and ask a question. Is self-defense, well, in State v. Hawley, didn't we hold self-defense cannot negate aggravated robbery? So even if it was self-defense, couldn't it still be aggravated robbery? Couldn't it still meet the elements of aggravated robbery?
I suppose that's true, yeah.
Then what, then I don't understand what your argument here is. How is this not aggravated robbery?
I'm arguing the evidence just wasn't sufficient to prove aggravated robbery.
Which
Separate of,
which elements?
I would say the taking by force. I've argued that there's
He
no,
had a gun, right? Your client?
my client did, so, and so did Mr. Fields,
Right, but
right? So.
but he had a gun and after Mr. Fields fell, he came back and took the gun, right?
It would appear, yeah, he testified that I came back, I grabbed that gun. And I know that there's no sort of like, it's not like a theft where we have to say to wit, we have to identify the individual property. But the only argument I've been able to, the argument that I'm making is that in that instance, that gun falls down. That was not what, he was not trying to take property from during that encounter. He was struggling with him in a self-defense situation. And I understand it's very hard to sort of parse those two events. I'm sorry. No, it's fine.
I understand that the eyewitnesses were equivocal at trial. But do you agree that on cross-examination, they were impeached by statements made to the detective to the effect of the defendant passing by Field before the shots were fired? That one of the witnesses said that the defendant told the victim, give me everything. That got into the trial as evidence. That the
Absolutely.
witness did say that to the
Right.
detective.
He did say that.
And it also got into the trial that another witness heard something to the effect of, give me it,
those two-
before the shots were fired.
I think Mr. Keeling had said something to the effect of, he's testified, where's my shit? Give me whatever. So, and like as I've argued in the brief, it seems like he's demanding something from him that he doesn't have, not trying to take something that he actually possesses. And then I guess my other argument that that I was making before is that, yes, those statements were made, but one of the witnesses, and I don't remember if it was the same witness that you're speaking of, Your Honor, but I know one of them went so far as to say one of the detectives offered him drugs during his interrogation about this in order to testify sort of in his favor. So That's the argument I'm making from sufficiency. It's just, and I know this court's not in a position to reweigh the credibility of the witnesses, but what I'm saying is that no rational juror in these circumstances could have put any sort of credibility on any of these, on any of the testimonies from any of the witnesses that were eyewitnesses in this case. Even Mr. Keeling, who would, I've argued, is the only witness whose testimony was consistent throughout. Just, I heard him say this, also admitted that, yeah, I was drinking and maybe I was a little loaded when I got there. So every single one of these eyewitnesses has a fundamental, it's a fundamental credibility problem that should have caused any rational juror to say, I have to toss out everything that they're saying because I don't know how I can find any of them credible.
What, get back to Justice Standridge's point. What about the evidence of the gun, taking of the gun? And we're here on a sufficiency standard. Why isn't that sufficient evidence for a taking to satisfy aggravated robbery?
I think it's very difficult, like I said, to parse it, but it looks like, you know, these two things are happening simultaneously. This supposed, you know, encounter where my client's trying to defend himself, and then the state's arguing that, no, actually, this is an aggravated robbery. So in an effort to defend yourself, if I've just disarmed somebody who I think is trying to kill me, it makes sense for me to take their gun. So
That's one version. And the other version is it's sufficient, there's sufficient evidence that he took the gun, and why at the sufficiency state, in the light most favorable to the state, that satisfies sufficiency for aggravated robbery.
and I understand that point, Your Honor.
Okay.
I do
Yeah,
for
okay.
sure. And I'm just saying that's
and
what
I
makes this
appreciate the
case very
intent.
difficult.
Yeah,
Is, you know,
I
we have
understand.
both of these things going on at the same time.
I appreciate
So-
the tension here, but it just seems like that. There, okay. Thank you.
I suppose, I guess the only other question, and that's really what I have to argue here, is that these witnesses are completely incredible. There's been so much equivocation that no rational juror under those circumstances should have accepted that testimony. Unless the court has additional questions for me on that.
May it please the court, Carolyn Smith on behalf of the state of Kansas. I would like to focus on the sufficiency issue, as I argued in my brief that if that issue is decided, the other two don't have to be met. And the reason is an aggravated robbery did occur in this case. As defense argues, the state didn't have to prove that Klesath ran up to the victim in this case with the specific intent of obtaining his gun, just that a taking occurred and that it occurred by force or by threat of force. In this case specifically, the jury was instructed that the defendant knowingly took the property from the presence of Mr. Fields. That taking occurred when the defendant, after shooting Fields, started to run away, but made the conscious decision to return and pick up the discarded gun. Then the taking occurred by force. Had Mr. Fields not struggled with the defendant, had the defendant not engaged, pointed a gun at him, had the defendant not shot him, Mr. Fields would have retained possession of his weapon. And at that point, as soon as the defendant picked up the gun, the taking was completed. The robbery was completed. There is no requirement for specific intent of robbery, and there is no requirement that the taking be the motivation for the crime as opposed to incidental to the crime. And that's a quote from State versus Edwards as decided by this court in 2014. Based on all of this, there is sufficient evidence that the defendant committed an aggravated robbery by taking Mr. Fields' gun. This court can disregard the eyewitness testimony if it so chooses and look at the video. The surveillance video provided by the liquor store and by the smoke shop provides several angles that the jury would have considered and reviewed. It was showed multiple times throughout the trial. It was slowed down during the trial for the jury to consider, and they could have reviewed it again during their deliberations. They would have taken all of that into consideration in viewing whether the defendant knowingly took this property, whether the taking was done by force, and they would have returned with the same decision that this was in fact an aggravated robbery.
I just wonder, you know, I mentioned State v. Hawley because it says that self-defense cannot negate aggravated robbery. But it does say in Hawley that that the use of force for the purpose of taking property from the person or presence of another can't be justified by the defense of oneself. By a way of an aside, we note that disarming an aggressor likely falls outside the scope of the statutory meaning of taking property. And that seems to be what appellant is arguing here. And how would you respond to that?
The state's argument is that Mr. Fields was not an aggressor in this case. He was hanging out with his friends outside of the liquor store. In the video, you can see them posted up against the outside wall of the liquor store. And they're just hanging out. They're talking to people as they walk up to the store. There is no audio, but you can see various interactions. Then during the video, you can see the defendant running up around the side of the building where he stopped short in front of the victim, and barely seconds of stopping, he draws his weapon and points it at the victim. Additionally, none of the eyewitnesses testified that they heard a threat coming from Fields when the defendant ran up. Whether or not they heard the defendant say, "Give me everything, give me your stuff," all three of them were. Mr. Fields was not an aggressor and would not have been a disarmed aggressor in this case. If this court decides to move past the sufficiency argument and go and address the instructional errors that were raised, it is the state's position that an involuntary manslaughter instruction would not have been factually appropriate in this case. And even if it were, the clear error standard could not be met. But first, it is the state's position that it was invited error to not give the involuntary manslaughter instruction because the defense during trial had initially submitted a supplemental jury instruction request that included an involuntary manslaughter instruction. During the jury instruction conference, counsel argued or requested various lesser includeds for aggravated robbery, which the court decided on, and then said there were no other requests. At which point the district court said, "Well, what about your supplement for lesser includeds for the second count?" At which point, defense said, "I don't think the testimony or the evidence elicited for the jury and provided to the jury would support my request for involuntary manslaughter." At that point, defense counsel moved into the second request for a different instruction, and there were no other addresses regarding involuntary manslaughter. Because that request was withdrawn, the court addressed it, and defense counsel said it's not appropriate here. Then saying it wasn't given was invited error. Even if it wasn't invited error, the facts simply do not support that this was a lawful act done in an unlawful manner, which is the instruction that counsel says should have been given. The facts of this case show that the defendant ran up on the victim and immediately brandished his weapon without being provoked. He pulled the victim off of the wall of the liquor store. He held the gun to him while they struggled, and then he fired 3 shots in very close range, hitting the victim twice. That does not support that this was a lawful act or that this was
Let
even
me just ask you,
self-defense.
it seems that we've moved to really what our factual inquiry is whether there was sufficient evidence to support the lesser included, in this case, the not requested lesser included. And if this jury had come back with an involuntary manslaughter conviction, would you be arguing that this was not sufficient? That's our standard.
I don't know that if the jury came back with an involuntary manslaughter conviction, that we would have the ability to argue that it was insufficient. However, the facts in this case show that the defendant's actions were intentional, which is the conviction that the jury came back with. They were instructed on intentional second-degree murder. They were given a voluntary manslaughter lesser. And in the instructions, they were told that if you do not find for this intentional second-degree murder, then you can consider the lesser. And had involuntary manslaughter been given, it would have been, if you don't find the voluntary manslaughter, then you can consider the lesser of involuntary. But the jury didn't even make it past intentional reckless second-degree murder to consider the lesser. And even then, it would have been very unlikely they would have even reached the even lesser of involuntary manslaughter.
Well, is that a problem in and of itself too, that it didn't get past the intentional? Why not the requested instruction on reckless second-degree murder? As long as we're going to dig into the instructional issues relevant to the merged conviction.
So the reason why a reckless second-degree murder instruction wasn't appropriate in this case is because a reckless second degree requires an unintentional killing. And in this case, the defendant testified at the self-defense immunity hearing that he intentionally killed Mr. Fields. And that testimony was provided to the jury and read into the record during trial.
There is also testimony from him that he didn't intend to kill him. He intended to stop him.
Additionally,
Why isn't that enough?
because additional testimony or additional evidence that was provided was from a jail phone call from the defendant who said, I was tired of looking around corners. He needed to stop the the victim in this case. He said, I needed to shoot to stop him. Additionally, the actions in this case show that he meant to point the gun at Mr. Fields. He wasn't just waving it around, telling everybody to leave him alone or to back up. He had his weapon on the defendant during the entire altercation, although the altercation was brief. He was physically entangled with the victim during this time, and then he fired not once, but 3 times towards the victim, even though he only shot him twice, and he was holding on to him the whole time until the victim hit the ground. That all shows or indicates the intent the defendant had while he was killing the victim in this case. And that's why reckless second was not factually appropriate.
Is that our test, though? I mean, you've given very good, what would have been very good closing arguments to the jury as to why they were going to find on the intentional murder charges. But our test really is not for the trial judge to weigh the evidence and decide which are the most likely convictions, but rather to look whether there was any evidence to support the lesser. And is there no evidence of recklessness?
No, there is not, Your Honor, because recklessness for this case would be under circumstances manifesting an extreme indifference to human life. And it's not simply, although it may be reckless to, hold a gun and potentially wave it around, it's not generic reckless behavior to point a gun at somebody and threaten them with it or or shoot them with it. Other cases.
You don't think it would be reckless to say, well, I'm going to stop this person. I'm just going to shoot him in the leg and then miss?
No, Your Honor, because,
Consider that reckless?
no, Your Honor, because in that case, in order to stop that person, you're intentionally pointing the gun at them. You're intentionally trying to stop them. And whether or not you're a
But
good.
you said he intentionally tried to kill him and even admitted trying to kill him. So what if the jury doesn't believe that? They have the right not to believe what a witness says, don't they?
That is true, Your Honor. They didn't have to take the witness's testimony as it was. The jury got to weigh the credibility of all the witnesses. The jury got to weigh the credibility of the defendant's testimony, not just once, but twice, because they heard the evidence from the self-defense immunity hearing as well. But the jury also got to watch the surveillance videos and look at the people from various angles and weigh that credibility as well in order to make their determinations. And as I argued with the involuntary manslaughter instruction, they didn't make it past intentional second-degree murder to consider anything else. They determined based on their review of the evidence that the defendant did in fact act intentionally, as was shown by the evidence.
But we don't really know what they were deciding inside that black box jury room, do we?
That is
They
true.
may have said, well, I think it's really more reckless, but that's really not a choice. You don't think there's evidence that could have justified that kind of a mental analysis?
Your Honor, I believe that it is possible. However, the avenue provided and instructed to the jury is if you don't find this, then the options are to go to the lesser or to acquit. And in this case, if the jury didn't find that the defendant was acting intentionally, they could have acquitted him of the count altogether, having not been given the option of recklessness. And even so, this all goes to the harmlessness of not providing the instruction, because the jury did consider all of this and didn't make it that far. They didn't waffle as to their decision and convict of the lesser, and they didn't acquit. And based on all of this evidence, all of the evidence in this case that does go towards his intent, it's unlikely they would have reached a different conclusion. Unless there are any other questions, I thank you for your time.
Thank you.
May it please the court, I guess I'd start initially with this sufficiency thing again. And the idea here is as Justice Standards brought up, the idea, as I said earlier, is this is a process of disarming an aggressor. This is a process of part of a self-defense claim. And I think why I would urge the court to get past that sort of merger difficulty that we have here is I think that then affects also the failure to give the reckless second. I think
Let me just ask you one quick question. Does it make a difference that, during the scuffle, maybe that's how you would describe it, that he actually left and came back before he took the gun?
I don't know that it makes a substantive difference as far as the argument of disarming an aggressor, because I'm leaving. This has been a really, the adrenaline and the whatever the situation. And I think it goes back to the idea of the robbery, and even in the first instance, it's clear that I'm not here to just take this guy's gun. And I know it's not a specific intent question, but he also is leaving when it suddenly sort of dawns on him that, wait, that gun's sitting right there, and I've got two of this guy's buddies sitting right there next to it. Maybe I should go back and take this gun.
You go back into the danger zone instead of just taking off?
Well, and I think that as he's turning his back to, and maybe he has second, my client has second. I mean, I'm speculating, but at that point, I would think it reasonable that maybe you have second thoughts about leaving that gun on the ground as I'm turning to leave with two guys standing there that are apparently his friends.
Just to confirm from the record, jury was instructed on self-defense, right?
It was.
Okay.
And if I can, this idea of getting past I think that the jury would have had a better opportunity to consider a fairer opportunity for my client to consider this question of whether that was aggravated robbery if they'd been instructed on second-degree reckless. And the facts support that. I put that cited to the State v. Gregory case, which is almost on all fours here. And the state and I think the trial court both confound the question, and that's not whether I intentionally pulled the trigger, it's whether I intended to kill when I did so. And the trial court denied that instruction basically on this idea. Very shortly, he said, well, there's 3 shots here and we all saw the evidence, so no, you're not getting that. Defense counsel didn't really try to argue any further than that. But I would argue that, yes, of course, it shows extreme indifference to the value of human life if I'm just randomly firing 3 shots off at somebody. And so that is the crux of really the argument of why that second, I would urge the court to consider that failure to instruct on second-degree reckless, because had the jury been given that second-degree reckless instruction, which made perfect sense under the facts of this case, it was factually appropriate, then that aggravated robbery would have probably, I would argue there would have been an acquittal of the aggravated robbery, because that makes a lot of sense in this case. It's extreme indifference, an unintentional killing. He said, I was there to stop him. That's what my first thought in my mind. And I see I'm out of time.
Real quick, I have a quick question. Based on the state's argument, I just wanted to get your response to the state's claim that the failure to give the involuntary manslaughter instruction was invited error.
I think it's not invited error. It was abandoned. And
Well,
so
why
I
is
think
it-
I'm under a clearly erroneous standard.
Why isn't it invited error? If
Because I
if
think-
defense counsel says this is not factually appropriate, I heard the evidence, I no longer think this is factually appropriate. Why isn't that invited error?
Because I think it's still reviewable under a clearly erroneous standard.
Well,
I don't
the question
think
of
the- I don't think-
the question of invited error is not, is it reviewable under a clear error standard?
I understand.
Was it invited error?
And if the defense counsel said, I think that's ridiculous, it doesn't meet the facts, then I would agree with you.
Do you dispute
I-
states?
I don't-
Do you disagree with the state's
can't say that
recitation
I-
of the record?
I can't say that I completely recall exactly what all I remember is defense counsel saying something along the lines of, I'm abandoning this. I don't think it fits anymore. Something sort of very short and flip, is how I recall the record. I want to say thank you for the court's time, and we'd ask for a reversal of Mr. Klesath's convictions. Thank you.
Thank you, and thank you to both counsel for your arguments today. The court will take this case under advisement. A court is